to Legally Speaking. With me, Tarun Nangiya. Today is a very, very special episode. Very soon, the 49th Chief Justice of India will be in office. Justice U. Lalit is taking over as a 49th Chief Justice of India. And it is very special. Your name goes down in history when you become the Chief Justice of India. And it also presents a lot of opportunities to the person who takes up this chair. So today we are going to focus on the opportunities and I have a very eminent panel to discuss Justice U. Lalit taking over as the Chief Justice of India. May I introduce you, eminent jurist, Dr. Abhishek Manu Singhvi. We all know he's a third-time sitting member of Parliament and served as the ASG earlier and senior advocate, one of the top in our country. Good to see you, sir, and looking forward to some interesting interventions. I have with me senior advocate Parag Tripathi, eminent jurist, one of the top counsels in the country, and who also has served as the ASG. Good to see you again. I have with me senior advocate Rohan Shah, again from practices at the Supreme Court of India and the Bombay High Court. Good to see you, Mr. Shah. And I have with me Mahesh Agarwal, managing partner, Agarwal Law Associates, who's one of India's top litigation law firms at the Supreme Court and other high courts. Good to see you, Mr. Agarwal. And without wasting much time, we have many panelists today. May I request Dr. Singhvi that in the first 2 minutes, if you could lay the ground before we move ahead. Dr. Singhvi, over to you.
Well, Tarun, you know, when you think of Justice Lalit, who's been with us in the bar for many years, appeared against us, appeared with us, you know, you tend to, what are the words which come to you in mind when you see him as a person? And I've always thought sobriety, extreme patience, very, very civil, understated person, a person with solidity without, you know, just superficial flamboyance. They are the kind of word which anybody who, and all of us here have seen him in the bar. So I think there'll be broad agreement with that. There is also, I think, firmness, but with a great politeness, the innate civility there. And I've always thought that, you know, that phrase, an officer and a gentleman, he's been a lawyer and a gentleman. Some people think they are anachronisms or oxymorons to use those two words. And he has also been a judge and a gentleman, very, very sober kind of a person. And he never believes in knee-jerk reactions, in denial of natural justice, in haste, and all those things. So I think his persona also defines the way he works. His persona defines the way he deals with matters. I'm not talking about his judgments. I'm not talking about individual cases, but I'm saying this is the man, the nature of the person. And gravitas is another word which comes to mind when you think of him. A great amount of depth, and he always wants to make sure that the person before him goes back with a feeling that he's been heard fully and comprehensively.
Thank you. Thank you for that opening comment. I'll go across to senior advocate Parag Tripathi for his opening comment. The first few words before we move into the discussion. Over to you, Mr. Tripathi.
Tarun, I think it was our Solicitor General, I was reading somewhere, who said that the defining feature, if I can use that expression, of our incumbent Chief Justice, both as a lawyer and in his avatar as a judge, was extraordinary patience and hard work. And that, I think, is true. Even when you argue before him and he's not with you, he will not shut you down. He will make it clear that the point is not going home, but he will let you speak and put your point through. I think that is very important, because ultimately justice is not only to be done, but seen to be done. It may not be perhaps the best way of dispensing high-speed justice turnover, because if you hear lawyers, and lawyers are very well known that there is no auto-stop mechanism when we argue. It does take a little more time than necessary. But I think at the apex court, that feel of justice being done is as important. And of course, he has a whole plate of issues before him as the Chief Justice. But we'll, of course, come to it later as we progress in the show.
Thank you. Thank you for that opening comment. I'll go to Rohan Shah. And Mr. Shah, your opening comment.
Sorry, really to resonate, what the two seniors have said, which is when you see Justice Lalit in court, I think the predominant feeling is one of calm, in situations of criticality, dealing with criminal law, important issues of civil law. The demeanor is constant. The way he conducts a court, I think, is just exemplary. Juniors always feel welcome, always feel that they will have an opportunity to address, making all their points. There are lessons which are very gently shared, whether with the bar or with litigants. And I think the entire situation, you experience is one of probably the highest level of dignity and efficiency, both rolled into one. And I think it's just an absolute pleasure. I personally choose whenever there is some downtime to actually sit in his court, because I believe just being there is a learning, and especially in criminal law, but across a whole wide spectrum of matters actually.
And people from Mumbai like you are also happy because he hails ancestry from Mumbai, and his father hails from Solapur in Maharashtra.
I guess the joy is that we have a Chief Justice of such standing.
Yes. So I'll go across to Mahesh Agarwal, who runs Agarwal Law Associates, one of India's leading litigation law firms. And you have a lot of matters in the Supreme Court of India for top corporates. And I ask you this for a reason. Justice Lalit's stint is short, but you know how much of an impact even weeks can make in Supreme Court. What are the opportunities? And then your opening comment also.
See, he has a huge number of opportunities, but I just want to say that we have seen him for over 30 years in the Supreme Court. He, I think, started practice in the Supreme Court in the chamber of Mr. Sorabji. Then he became an advocate on record. And his credibility and the confidence which he has enjoyed from the court is seen that he has been appointed as amicus curiae in several cases, successively and for a long period of time. Then when the 2G case started, the court was looking for somebody with impeccable reputation who could conduct the trial, and he was appointed as a special public prosecutor by the Supreme Court to prosecute the 2G case. So the sheer confidence which the Supreme Court over the years has placed on him is really impeccable. And that supports what my learned friends have said, his calm nature, quiet, lot of confidence, good amount of interaction. So that has really taken him to different places. Now, what I hope is that since he has had maximum experience in the Supreme Court amongst many other people, he would know what issues need to be corrected, what improvements have to be done, and how we can have a better Supreme Court laying down the law. For instance, a simple thing that we have a huge number of over 400 constitution bench cases pending in the Supreme Court which are not being heard. In the last 2 years, there have been hardly any cases that have been heard. So if some procedure can be sorted out that without kind of spoiling the routine of regular cases, the final hearings can be taken up or the constitution bench matters can be taken up, that will go a long way.
Thanks for that opening comment. I'll go to Dr. Singhvi now. You appear in some of the most important cases in the Supreme Court. You have appeared before Justice Lalit. And now, of course, you will again get an opportunity to appear before him when he is the Chief Justice of India. Could you run us through some important of his judgments that you feel that you need to share with the audience? You're not audible, if you can.
Justice Lalit has authored many judgments, as we all know. But just to give you a quick thumbnail sketch in the limited time available, the diversity is very interesting. One of the most interesting, of course, was the Travancore Padmanabhaswamy temple judgment, where he labored hard and long and, in fact, appointed another amicus to actually hold that the Verma family's heritability is revived. It had been set aside by successive judgments. And that whole concept of temple treasures not going under the hammer with the court administration or the government's trust was changed. And he said, no, heritability must attach with the Shebayat, with the servitor of the temple. And that was a very high stakes matter, but he went into great detail on the history of the temple. He has done, and people don't remember that he probably was deciding the tilting number in the triple talaq, because there was very clear from the beginning there were two versus two. And he was the fifth judge who tilted in favor of the majority in the so-called Shaira Bano case. He got some flack, a lot of flack, unnecessary, I thought, in reading safeguards into the SC/ST Act, an act which at least practitioners know is frequently abused. And all that the bench did, to which he was a party, was to read in very welcome safeguards. But they face a lot of flack, and I'm very happy that they stood their ground stoically, but in a dignified manner in that judgment. So there are many of these cases. There has been the case about this very unfortunate and strange finding of skin-to-skin contact in POXCO, also came from Maharashtra, Nagpur. And he held that sexual intent matters, not the skin-to-skin element. And there is another judgment of his, and so on and so forth. The so-called mandatory 6-month waiting period between spouses for divorce has been held to be not mandatory by a bench of his. A lot of these judgments are there, but one thing before I end on this, I found it interesting as a practitioner in the bar when we appeared together on the same side. I found him very, very good and also technical in criminal law in terms of, understanding the nitty-gritty. And he would not be swayed by mere so-called equities or emotion, which are sometimes playing a role in criminal law. It's interesting that as a judge, I don't find him that technical at all. And I find that he is influenced, as of course a lot of people are and possibly should be, with the larger contextual equities of the criminal law facts situation. So there's been a change in that sense from a practitioner to a judge on the same subject.
Thank you. Thank you for sharing that perspective with us. And you mentioned one thing that, you appeared alongside him in some matters. That's why I take it up. He had a flourishing and a good practice, yet he chose to take up a position on the bench, which requires a lot of doing. So I'll go to Senior Advocate Parag Tripathi for his comment. And of course, because you have a very busy Supreme Court practice, I'm sure you would have met him or you would have had the opportunity to appear alongside. Could you share any anecdote which you'd like to share with the audience? You're not audible.
His extraordinary aspect in him, which comes out both as a judge and as a lawyer when he was at the bar. And here I would like to tell Rohan that from 1986, he was in Delhi. So we really treat him as a member of the Supreme Court Bar of Delhi and not really of the bar to which, the distinguished bar to which Rohan belongs. One thing which comes out and came out even when he was a lawyer, strikingly, was that he was quiet, he was persuasive. And even when he found or persuaded you, if you are on the same side particularly, that there is a flaw in your argument and there's a better argument available, he would A, share that, and B, he would not push the point or push the argument beyond the point. He would leave it for you to understand that, look, this is where you are going and this won't go far enough and this is the way to go. So that aspect of him has remained, and that is a remarkable aspect, because many times people do change when they sit on the bench, because of course the nature of work is different and you have to be decisive in a very different way. Because we have had several examples of great lawyers not making it with the same amount of excellence on the bench, particularly in the high courts, because it's a different skill set. So he has adapted and adopted to both the skill sets with great aplomb. And I have no doubt that once he demits office in November and if he decides to go in for arbitration, he will then do the same when he sits as an arbitrator, because these are separate skill sets. So my memory of working with him was, of all things in a criminal matter, was where I was roped in, as it were, because that is not my forte. Not that civil matters are, but criminal matters certainly are not. And what I liked about his argument was that he would slowly develop it, and then, like a game of chess, leave no option with the judge but to go the way he wanted the court to go. So he would shut out all other options of thinking and jurisprudential approach. And that, I think, is an excellent approach, which can only come, of course, if you have thoroughly read your brief and you know your law.
Thank you for that input. I'll go to Advocate Rohan Shah for his comment.
I mean, just to share, I've been following quite closely a set of matters where the central issue was that people who were on death row, should they actually go down that path, or was there an option? And I think I saw over a matter of 3 or 4 days how he really evolved this into a completely different realm of now saying that it is mandatory that there be a psychological evaluation of the person, that their history in terms of the conduct while in jail is an important determinant, and that no matter how grave the offense, that in society there must be place to relook at some of these sentences. And I think his classic quotation of Oscar Wilde that every saint has a past and every sinner has a future, I think has, really amplifies his approach. And I think I've really been struck by the factor that he's brought that sort of empathy and opened up the consideration, even on a sensitive issue, criminal law issue like this, to aspects outside just the narrow focus of the law. And to me, that's been remarkable, because that's a legacy which will have a deep, deep impact.
Okay. Thank you. Thank you for that comment. I'll go to Mahesh Agarwal, Managing Partner, Agarwal Law Associates. Mr. Agarwal, every Chief Justice has got an opportunity to go down in history by etching his personality on the institution in a way. Some decisions he takes could be by how cases or mentioning happens. There are aspects to what do you think are the opportunities that Justice Lalit, of course, appointments will happen during his tenure. Judicial appointments will happen. Tribunal appointments will happen. That's one aspect. Could you share some of these things with us?
Yeah, I think with his demeanor and his nature of being soft-spoken and firm, he should be able to carry the court with him and try and make some systematic changes.
Yes.
For example, the usual problems which we are facing for some time is that for listing, we have to keep mentioning cases and they don't get listed. Earlier, there was a system of automated listing. The matters get, say, numbered by Tuesday, Wednesday, they get listed in a week. Nowadays, that's not happening. So we have to unnecessarily trouble the court, and a lot of litigants' time and money is wasted in ensuring that he gets a hearing. Now, being in the apex court, if a litigant is assured of a fair, even approach, that he will file a case, it will be heard, it will be listed, it's a big relief for a litigant and gives a lot of confidence. So some of these things, if they can be sorted out in his short tenure, that will have a long-lasting effect. So, simple words, nobody wants to mention matters, nobody wants to run to court, nobody wants to do things if they are done automatically. And there is a system in place now. The Supreme Court is completely automated. The filing is automated, numbering is automated. There are systems in place that things can be managed very well. So if he can put in some effort on that part of the listings procedures, that will give a lot of confidence to the litigants.
Thanks for that input. I'll go to Dr. Singhvi. So one important thing I want to ask you, I remember when you had contracted COVID long ago, I think 2.5 years ago, you were arguing a lot of matters even then and online. And you did wonderfully well. You wrote an article that time about what your experience was. Could you share with me that how do you see the online system of hearing going under Justice U. Lalit as Chief Justice of India? Could he institutionalize it? Could he take some decisions which will be, because I think it's a part of life for us, to see now lawyers appearing online for matters.
See, I think this whole thing has to be seen in the context of the known fact, which everyone and above all Justice Lalit knows, that he has a tenure but a very short one. So I think we are looking at it as a window from August to November, which may not be quite accurate. He knows this, the system knows it. So I think first and foremost, he decided that his legacy as a Chief Justice will be left in his headship of the legal aid body, which as number 2 and number 3, he has headed now for almost 1.5 years and 2 years. That is, I think, very clear with in the amount of effort, the amount of focus, the amount of travel, the amount of energy which he has put in. And you've got figures published recently about great strides in that field in terms of achievements, reach, access. And I think that is the part of the Chief Justice's aspect which he has said is the best he can do out of a short tenure. So it's not just this window. Secondly, I think he will show flexibility. And if he shows flexibility, then he will also get flexibility from all the others. Now, I don't see him doing anything drastic like abolishing hybrid or virtual options. It is an open secret that his successor is clearly in favor of that. And therefore, you will find that continuity in it clearly there. You might find enhancement. You might find digitization at a faster pace because everybody knows that between him and his successor, the time is very short. So I think there will be no problems. I think the real issue would be that he doesn't have time to make a mark as too many appointments. But yes, he will strive in that direction also. And I think there should be no problem about the cooperation and the continuity with his 2, 3, 4, etc. down the line.
Thanks. Thank you for that comment. Now to Senior Advocate Parag Tripathi. Sir, you also, whenever I've spoken to you, heard you appearing before the Supreme Court of India, then some other forum also from your office. And you told me that it has become a part of your life. So how do you see this going in Justice Lalit's tenure? And anything that he can do in that respect, or any other comment you may have?
No, I think I'll agree with Abhishek that the tenure, unfortunately, does not do justice to the incumbent Chief Justice. And that really raises that bigger issue of tenures of Chief Justices, because it's a position, a constitutional position of continuity. And that's something, of course, which can't be decided on a case-by-case basis. There has to be an institutional decision on it. There are a lot of big issues also on the plate, both big and small. For instance, you have purely administrative issues because Justice Lalit thought out aloud and said that why not we have a court which opens at 9 a.m. or 9:30 a.m. He in fact sat also one day at 9:30
Yes.
Now, these are issues which I think the full court should really deliberate and put a stamp on it. It's not a bad idea at all if it can work out, subject, of course, to the problems of location and geography and distances. And there again, virtuality will help. But of course, the court staff will have to come physically. But these are aspects which have to be worked out. Then there are aspects which I call quasi-administrative. For instance, the pendency of Constitution Bench and a seamless system where Constitution Bench matters also see the light of the day, a point which Mahesh made very tellingly. Then there is the other issue which suddenly cropped up about seniors and mentioning. I think it's a very healthy idea to say that seniors shouldn't mention, but then that should be a uniform decision of the court without any exception. That is why, because as Mahesh said, clients know that if a senior mentions, there's a huge amount of monetary, if I may say so, expenditure. I won't say loss, but monetary expenditure which follows. So if they know that seniors will not mention, then in big matters, it will greatly help the younger bar to be groomed. But if they feel that, all right, if I don't brief a senior, the other side will get one, and maybe there will be some imbalance there, then there is no option. So these are things which I think the full court must sit and then uniformly follow it. Because unfortunately, in some courts and among some of us, there is this feeling that the individual decision making on the administrative side in respect of the own court of a judge in some ways transcends the institutional decision-making of the court in terms of the administrative side procedure. So there has to be a clear uniformity there. For instance, there used to be a big issue whether there'll be a passover in the 101 series matters. There should be a clear understanding, yes or no, and then it is followed. That's what I feel. And then lastly, I think is a much bigger issue of the roster powers of the Chief Justice. Yes. Now, that's an issue which is very important because as many of us have said, that Indian Supreme Court is unique in many, many ways. One of which is that in some sense, there are as many Supreme Courts as there are, with great respect, the distinguished benches, because benches have at times very, very different views. So whereas rostering, of course, the Chief Justice is the master of the roster. But the question which has arisen of late is that whether within that roster, assignment is something which can be left to the decision of the Chief Justice, should be left to the decision of the collegium, or should be made completely automatic, as happens, say, instance, in several high courts like Delhi. But then these are, that's right, but these are very big issues. And as our panelists have said, that a very small period of 2 months and a few weeks may not be enough to resolve it, though I think the sage advice of the incumbent Chief Justice will go a long way. But I think there has to be an institutional mechanism where a collegium functions so the baton is passed off seamlessly, and these decisions are done on a continuity basis and are uniformly followed, because the uniform following is very important.
Point very well taken. Thank you for sharing those points. And we have about 2, 3, 4 minutes to go. So very quickly to Mr. Rohan Shah, on the digital hearing, I remember talking to you, I think, last week, and you said how convenient it was to appear before the Supreme Court, Delhi High Court, where you also appear, digitally, time and cost, other advantages, I think you told me that time. Could you share with us on that front? Do you see, that courts will make strides in that aspect?
To me, I think it's a situation where the last 2.5 years have proven the efficacy of the system, proven the advantages in terms of not only efficiency, but also economics, for litigants. So in the tenure that Justice Lalit will have, I think, as with all tenures of this type of period, you will see some things which are affirmative of the past, and you will see hopefully the opening up of some agenda items which will only fully fructify into the future. But as far as digital hearings or hybrid hearings are concerned, I think there will be a continuity and an endorsement, and which over time may gain far more vigorous support.
Okay, thank you. I'll go to Mr. Mahesh Agarwal, Managing Partner, Agarwal Law Associates. Mr. Agarwal, if you could, as a sort of an ending comment, give me about 2 or 3 points which you think the Chief Justice of India could consider to accomplish or to move forward to, since from a law firm standpoint, where your law firm appears in hundreds of matters, you can give me that sort of an input. Could you share 2 or 3 things which are top of your mind, which can be done in the short tenure that he has?
The first thing what Mr. Tripathi said should happen is uniformity. You see, we have 10 courts, 10 forums, 10 procedures. At least on procedural aspect, there should be complete uniformity. If you have a virtual hearing, it should be allowed in all courts. You cannot have a situation that 6 courts are virtual and 6 have hybrid. So uniformity in the way of hearing, either virtual or physical, very important. Uniformity in the procedures of mentioning. Some courts have listed mentioning, some courts have unlisted mentioning, some don't have any mentioning. So what matters can be mentioned, should not be mentioned, how they have to be mentioned. There has to be a uniform system. Similarly, in terms of listing also, there should be uniformity and transparency, which is just now missing. So these things are very critical. And I think if 3 or 5 senior judges sit together, even on the procedural aspects, and agree to a uniform path, then things will be much better and smoother for everybody.
Thanks for that comment. I think I have last 1 minute. Dr. Singhvi, do you have one last comment to squeeze in before we close the show?
Well, I think we've covered a lot of things, and basically everybody wishes Justice Lalit well. But most important, everybody wishes that there is a greater feeling of continuity in the Chief Justiceship line. And each Chief Justice thinks at least 3 Chief Justices ahead of him. That is what is missing and has been missing in the Supreme Court. And everybody knows that their tenures, his is a very short one, but they know otherwise also that there may be shorter tenures in the Supreme Court. We don't have very long tenures anyway. And if that degree of fraternity, judicial fraternity, in terms of planning out, as you do for economies, a 5-year plan, where at least a 1-year plan and a 6-month plan for the future and handing over the baton successively, that will make an immeasurable change. Everybody must leave their stamp. But the stamp should not mean that they're all pulling in different directions just because it's over. And I think that is going to happen as time goes on. There are younger people coming up, and all of them have that have that spirit in them to try and work together. And I just hope and trust that that happens.
Thanks so much, Dr. Singhvi, Senior Advocate Parag Tripathi, Mr. Rohan Shah, Mahesh Agarwal, Managing Partner of Agarwal Law Associates. And I appreciate that every time, even the last time since we started, the Chief Justice of India takes over, you all come together, put in your suggestions, compliment, because I think we owe it to them. They take up this responsibility for all of us. Judging is not an easy job. You are always subject to criticisms. But it is really a crown of thorns, as many put it. It's not that easy to be a judge. Thank you so much for finding time to come for this show. Thank you so very much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.